Well, good afternoon, everyone. I hope that you can all hear me okay. And I'm so thankful that you are giving us some of your time this afternoon. My name is Michelle Dexter. I am an attorney here with Keystone Law Firm. We practice estate planning, trust administration, probate, guardianships, conservatorship, and we have done some long-term care planning with irrevocable trusts, Miller's Trust, and those types of things in the past. So we wanted to do this presentation today on Medicaid because more and more of our clientele are running into issues where they're looking for additional caretaking, additional caregiving, assisted living, skilled living places, and obviously we're all worried about the costs of those types of things. So today's presentation is really intended to help share information about Medicaid, what it provides, how you get qualified, and some of the strategies that might be available based off of individual circumstances on how people can kind of work with the strategies that ALTCS allows to get qualified. Because I know a lot of people will look at the rules that ALTCS provides and just be like, oh, I'm never going to qualify, end of story, and then it just causes a lot of stress. So we want to make sure that people are aware of what ALTCS provides and what that looks for. Medicaid and ALTCS really are the same thing. ALTCS is Arizona's long-term care system, and that is Arizona's version of the Medicaid program, okay? So Arizona's long-term care system, ALTCS, you might hear me kind of refer to ALTCS or Medicaid interchangeably. Every state operates its own Medicaid program, and the rules can vary by state. For example, here in Arizona, we have a 5-year look back period. I know some other states have a 3-year look back period. And so those are just things to kind of keep in mind when you are looking at this information, but you might be in another state, or you might have a family member in another state who might look to apply for or qualify for these types of benefits, okay? So the main things that we're looking for is age, U.S. citizenship, medical qualifications, and income and assets. Okay, those are the primary qualifications that you're looking at when you are looking at applying for these types of benefits. Okay, so what does ALTCS provide? Okay, payment for skilled and assisted living facilities, home and community-based services. Okay, so you might be moving into a facility that's providing services, or you might be having somebody that comes in a few hours a week to provide services. Either one of those, right? It will include medical services, therapies and equipment, the dental care, your care coordination, and some hospice care, okay? When you apply for ALTCS, they do have a couple of different medical plans, and you're asked to choose one. I see a lot of times, especially like through Facebook and community boards, that people are asking, what's the better one to sign up for? When you're looking to apply for ALTCS and get these types of benefits and choose which medical plan, I highly recommend that you look at the facilities that you might be interested in being placed and find out what medical plan they accept, because that's really, at the end of the day, going to be the important thing. ALTCS is a program that not every assisted living facility accepts. Okay, so you've got to find out which facilities accept the program, and then find out from there which medical plan do they accept. And so when you're looking at applying for these things, sometimes some of that work is stuff that you want to put into in advance of getting there and trying to figure out which one you want, okay? Age requirements. Here in Arizona, we've got the ALTCS program, and that's usually for most individuals under the age of 65. That is like a health insurance program for those that can't afford based off of their requirements. I was going to say, a lot of us with current healthcare costs feel like we can't afford it, but based off of their requirements, ALTCS is the program for most individuals under 65. ALTCS is primarily for the individuals over 65. If you're under 65, it requires some more serious level of disability, a blindness, a qualifying physical, developmental, or mental disability. So for the most part, when we are looking at ALTCS support, we are looking at it for those clients that are over the age of 65. Okay. U.S. citizenship requirements. If you are a U.S. citizen, you have immediate eligibility. If you are a green card holder, you have a 5-year wait from the time that your entry is a qualified status. If you're a qualified non-citizen, my understanding is the wait times vary, but if you're an undocumented immigrant, you're not eligible at all. So one of the reasons, I guess, to try to get your citizenship or at least a green card, okay? Now, medical qualification is one of those things that can be a little bit more discretionary, right? If your loved one is already placed in an assisted living facility, in our experience, that is generally making the medical qualification happen relatively quickly and easily, okay? I was talking last night with a friend of mine who works for the Agency on Aging, and she was saying that they're really, ALTCS is really making the medical qualification a little bit more difficult. I think they probably have so many people that are looking for these types of benefits, and so they're really looking to make that qualification aspect of it a little bit harder. If you are not currently in an assisted living facility, or if your family member is not in an assisted living facility, maintaining good records prior to the application is going to be really important, okay? You want hospital visits. How many times have they fallen? What types of injuries have they had that do not require hospital visits? Having that type of documentation in advance can really help the evaluator get a bigger picture than just the 30 minutes they're coming in to evaluate your loved one, okay? You also want to keep a log or track their ability to do regular things for themselves. They call them activities of daily living, ADLs is what you'll see it as. I believe there's a list of about 60 items that they check off, but can they make their own food? Can they drive? Can they grocery shop? Can they bathe on their own? Do they have to have instructions for everything? Or can they, what types of things can they do on their own? Can they feed themselves if somebody's made the meal? Can they dress themselves? Those are all the types of things that the evaluator is going to want to know whether or not they can do. And for those of you who have experienced some people that have Alzheimer's or dementia, a lot of times they can fake stuff pretty good and be pretty convincing for, a 15-minute conversation. Oh, are you feeding yourself? Oh, yeah. And meanwhile, you're in the background going, no way, they haven't been able to do that, in years type of thing. So you want to be able to provide that information as part of that medical evaluation so that you are supporting the need and being able to demonstrate to the evaluator that this medical qualification and need is really there, right? Income requirements. Okay, so U.S. citizenship, age, and medical stuff, that's just kind of be what it's going to be. You're either over 65 or you're not, right? You're either medically qualified or you're not type of thing. The income is one of the first places that we can get into some creative strategies or looking at alternatives for how we manage that, okay? Now, the income limit goes up every year. This year, it went up a whole $81 from last year. So you can currently have $2,982 for an individual in income. We're talking your Social Security, we're talking your pensions, we're talking your IRA distributions, those types of things. If your income exceeds that $2,982 amount, then you're looking at what we call a Miller's Trust, and we'll talk about that a little bit, okay? But for the most part, and this is where people get hung up a little bit, they see my income's over $29.82 per month, I'm not going to qualify, and that's kind of where they give up. But that's the type of thing where we want to, talk about, do we need a Miller's Trust? What other options do we have, right? If you're a married couple and only one of the two of you is needing assistance, we can do some different things with that income. We can do what they call name on the check. So if my income comes in my name and my husband's income goes in his name, they can separate his income from my income and calculate how much income each of us is receiving and whether or not the person who needs the benefits is falling within the guidelines, right? And we'll do some examples of this in a little bit to help you kind of see that. But if my husband needs long-term care and we're applying for Medicaid for him, but the majority of the income comes in his name, right? That may not be the best way for me to handle it, is name on the check, because then he's over, I'm way under, right? So another alternative is to do what they call a 50-50 division of community income. And so we could just say, we're just going to combine all of our income in 50-50 and see where that lands, both of us, okay? And again, I've got some examples coming up with some additional things that can happen with regards to that, but I just want to kind of give you guys a foundation of what happens with the income. If we've got a married couple and both are needing the assistance, the combined amount that you can have for income is $5,964, okay? Again, there is the Miller's Trust, and we can talk about that and what that looks like. But, you know, if you both need care, that is that kind of maximum number that you can have in terms of income without needing to do anything extra to qualify for ALTCS with doing a Miller's Trust or something, okay? So I like examples. So individuals needing ALTCS benefits, if Sally's income consists of Social Security, her late husband's pension, her required minimum distributions from an IRA, and her total income is $4,500, she's over our income amount, right? Some income sources can be adjusted to decrease the monthly income being received. So for example, if Sally's regularly taking more from her IRA than just her RMDs, then maybe we can reduce that amount and try to minimize what she's pulling out of there. But obviously with Social Security, those of you that actually have pensions, there's no flexibility there, right? So for the income that goes over the amount, right, when the income exceeds the income limit, then an income-only trust is the appropriate vehicle to allow for qualification despite being over the income limit, okay? An income-only trust is also known as a Miller's Trust. There was a case that was what created this Miller's Trust, and so that's where the name Miller's Trust came from. But sometimes you'll hear it as qualified income trust, some income-only trust, Miller Trust. That's the type of thing we're talking about, okay? So when we create a Miller's Trust, the gross income is deposited into the trust account, okay? So your Social Security, your RMDs, your pension, all of those funds are going into a new account that's titled in the name of this Miller's Trust, and it has to be the gross amount, okay? So there's no deductions being pulled out. If you're still paying for life insurance or paying towards other benefits, those all have to stop because the gross amount has to be deposited into the bank account titled in the name of this trust in order for the trust to be effective, okay? From there, ALTCS will determine what is the share of cost. They will give her a personal needs allowance. I think right now that's right around $200 per month that people get for their personal needs, and that can be used for haircuts or, you know, having your nails taken care of or buying clothes, or, you know, unfortunately it doesn't go very far. And so, but that's what they allow. And then your Medicare costs also come out of that, okay? Now the trust may have some excess money in there every month. And the excess money can be spent on some very limited things for the personal costs of the person receiving benefits, okay? Any money left in that trust account at the time that that person, in this case, Sally, passes away, that is subject to Medicaid reimbursement, okay? And so what that means is that when you pass away, the Medicaid program is going to come in and say, we've spent $100,000 on your care. This trust has $5,000 in it. We're taking the $5,000 and nothing else is going to anybody else, okay? And so that is part of the reason that Medicaid allows this, is because if there is any money that's left over in there, they're entitled to it as reimbursement, okay? Now, when you're creating a Miller's Trust, there are really, really strict compliance that has to be done with the rules in terms of the timing of creating the trust and opening the account, getting the money deposited into the account, and accounting for all of the distributions. So you really want to make sure that you're paying attention to the terms of the trust. When we do the Miller's Trust, within the terms of the trust, it has all of those rules specifically laid out. You want to review that periodically. You want to make sure that you're getting that taken care of. And really the first part of it, getting the trust done and getting the account open, and then getting all of the income to come into the accounts as the gross amount and not ideally automatically deposited, is kind of the toughest work of it. From there, it's a little bit easier, and then you're just kind of doing some annual accountings to ALTCS with how the money was spent. Not every bank in our experience has understood what the Miller's Trust is or allowed it to be opened. So in our experience, we have one or two financial institutions that have allowed this in the past, and that we typically send our clients to. And I've even had it where this bank may have 10 branches in Arizona, but I have to send everybody to one specific branch. I think they're up by the Biltmore, because that seems to be the only people that seem to know what we're talking about within their company. So it can be very frustrating at first to try to get it all set up, and you're trying to get it all set up at the time you're trying to qualify for ALTCS at the same time. So it can be a little bit stressful, but know that if you can get over some of those hurdles, it's going to be worthwhile to get there with that. Okay. Our next example is when we have one of our two spouses that need benefits. Okay. So again, the name on the check, right? If husband's income is $5,000 per month and wife's income is $2,500 per month, if wife is the one that needs benefits, husband actually gets to keep his income. He gets to keep his $5,000 per month. The $2,500 per month that she receives is going to go towards her share of cost and her expenses. Okay. It is kind of nice that when you do name on the check and the person needing benefits is the lower income earner, because you can tend to keep a little bit of a higher amount for the healthy spouse. And that can be really great because the healthy spouse doesn't have an income cap on money that's in their name. Okay, so if your spouse earns $10,000 a month and you earn $1,000 a month and you're the one who needs care, they're going to take your $1,000 a month, but your spouse gets to keep their $10,000 a month. And one of the things when you're looking at these things is really trying to make sure that the healthy spouse can maintain their standard of living, that they can pay for all of their expenses on this reduced income. Because even though ALTCS is going to cover the difference between what you can pay in your cost of share and what the cost of the facility is, the truth is that we need to make sure that the healthy spouse can still afford to have their, maintain some lifestyle type of thing. The second option is that 50-50 split of income. So if the husband's income is $5,000 per month and wife's income is $2,500 per month, but husband requires benefits, they might do better to combine their income, each of them being assigned with $3,750. We know that husband's still going to need an income-only trust, but that's going to allow him to get qualified and is going to somewhat maximize the amount of money that wife is going to be able to keep. Okay. Now, ALTCS has what they call their minimum monthly needs allowance. It refers to MMNA. You'll sometimes see that acronym. Okay. What it provides is that the healthy spouse is entitled to a minimum monthly income. Okay. The minimum is that $2,643 and change, and the maximum is $4,066.50. In order to be above the minimum, you have to demonstrate that your expenses justify the additional money. So, for example, if we had two spouses that were only receiving $1,000 a month or $1,500 a month, one spouse is keeping their income, but they're getting a income shift from the other spouse to make sure that they're hitting at least that minimum of $26.4375, if that makes sense. Okay, so the goal is not to leave the healthy spouse completely broke, but for most of you, you realize that this is not a huge amount of money to pay your monthly ongoing expenses, so it can definitely make it tough. Okay. When we've got a married couple and both of them need benefits, then you're looking at which one makes more sense. It could be that, name on the check requires only one person to need an income-only trust at that point in time. If in the 50-50 split of income in that example, it could make it so that by doing it as a 50-50 split, that neither of them need an income-only trust because we've kind of spread out some of husband's income over wife's, if that makes sense. So, name on the check, husband would need the income-only trust because his income is $5,000. But if his income was only $3,000, he would need an income-only trust, except for the fact that we're going to kind of divide that up with his wife's income, and then that's going to put them both under the income requirement amount. All right. So then in that case, neither of them would need that income-only trust. And so, the benefit is to just use what the options are and strategize to what's in the best interest of your family in that regard. Okay. So for resources, the limit is $2,000 in resources per person. Okay. Now, people are always like, that's so low. But the reality is that the goal is not to give benefits to people who can pay for it themselves. Okay. So you may have heard that there are some things called non-countable resources, right? So your primary house technically is not counted as a resource, and your first vehicle is not counted as a resource, okay? So those are not going to count towards that $2,000 limit. Now, there is some limit in regards to how much equity you can have in your primary residence. That's something that you'll need to deal with. But more importantly, things that you want to consider is that Arizona is an estate recovery state. And what we mean by that is that while they may not count your house as a resource for that $2,000 resource limit, they can put a lien on the house so that when you pass away or when you sell the house, they can get reimbursed for what they've paid for your care. Okay. And so while it sounds really great that the primary residence isn't going to be counted for those purposes, the truth of the matter is that more than likely you're going to end up spending down the equity in that house for your own care as a result of that lien. Okay. When we have a healthy spouse who's still in the home, it's our understanding that ALTCS typically does not lien the house when we have a healthy spouse living in it. The problem is that the healthy spouse isn't always guaranteed to outlive the spouse needing benefits. And so there's no guarantee that the house won't eventually be liened or need to be sold in the future and have those monies come back through Medicaid. So if you are getting qualified and the primary residence isn't going to be counted and they're not liening it because of that healthy spouse, you want to make sure that you're taking whatever steps you can to help protect that house after the qualification. And that may be being able to, maybe put it into a trust or putting some kind of other transfer deed on there so that we can try to avoid probate, certainly, but also to see if we can make it so that it doesn't come back through Medicaid. Okay. The one vehicle for most married couples, when one person is going into an assisted living facility, they don't need two vehicles anyway. So that's usually less of an issue, and they don't typically lien the vehicle. So that's not an issue. Okay. One thing I want to make sure you guys all realize is, so I've been doing this for 9 years now. They haven't raised that $2,000 limit once. Like where the income gets increased each year, just a little tiny bit. The resource allowance has never been increased, and I haven't heard any conversation about increasing it. Okay. So countable resources are non-income generating assets. So think of your bank accounts, your brokerage accounts, if you have a second home, if you have cash in a cash surrender value in a life insurance policy, those are all going to be counted towards your countable resources. Okay. Now, if you are married, your healthy spouse can have a minimum of $32,532 in resources, but they can't have any more than $162,660 in resources. And so for a lot of us, that really is a little nerve-wracking to think that all of your nest egg is going to be kind of reduced to that $100,000, figure type of thing. Resources are counted at the time of application. So in the event of a married couple, if they have $100,000 in assets at the time that they applied, ALTCS will consider each of them to have had $50,000. The healthy spouse can keep his $50,000 or her $50,000 because it's over that $32,000 limit and under the $162,000 limit. But the spouse needing the benefits is going to have to spend down $48,000 of that to get down to the $2,000 of their share. And so sometimes there's some strategy there in terms of applying and trying to get qualified at a point that the healthy spouse can maximize how much they can keep, even though we know that the spouse needing benefits is going to have to spend down a bit of money. But you just kind of want to strategize, again, be aware of what the rules are and strategize with some of that. Now, things we want you to consider, as I mentioned at the beginning, Arizona has a 5-year look back period. Okay, so from the date that you apply, they're going to look back and they're going to request bank statements and documentation for 5 years prior. Okay, they're going to review that stuff and they're going to say, hey, I see here that you made a $200 cash withdrawal. Where'd that money go? Right? And they're going to give you this laundry list of things that they want you to provide answers for. And then they're going to give you like a week or 2 or 10 days to respond, right? So it definitely can be helpful if you're going to apply to pull 5 years worth of bank statements for all of your accounts and review through them to see what types of things might they ask for. Do you have the check register for all the accounts? Do you have every transaction kind of identified, right? You want to make sure that that portion of the application process can be a little bit as easy on you as possible. So again, having a little preparation in advance can be helpful with that. Anything that they see as a transfer without compensation, so gifts essentially. I gave away my car, I gave away my expensive jewelry, I gave away money from my bank account. That is going to trigger a penalty. Okay, and so they're basically going to say you gave away $50,000. We're going to divide that by the average cost of care. And I think right now their divisor is right around $10,000 per month. And we're going to say if you gave away $50,000 and our divisor is $10,000, that you have 5 months that you have to self-pay before Medicaid is going to step in and start paying for you. Okay, and so sometimes you might trigger that knowing that you've given away some money, but you're going to be able to self-pay for the penalty period and you're good with giving away that money. Sometimes you might have to go back to those people and say, I need that back, so that they don't cause a penalty, but then you're going to have to spend down those things. Okay. For some of our clients, they're stepping in for a parent or somebody that they really haven't been managing their money for the last 5 years. And so when the ALTCS comes back and says, what happened with these transactions, they really aren't going to have an answer. ALTCS isn't going to necessarily expect you to be able to figure out something, especially if you don't have the party who was conducting the transaction capable of communicating what it was that they did with those funds. And so you're just going to have to do your best to be like, this is when I took over managing their funds. This is when I realized it was a problem. Before that, I wasn't involved, and they've got dementia or they've got Alzheimer's, or they just don't have the ability to communicate what happened during that time, and hope that ALTCS is going to be gracious enough to not trigger a penalty with some of those transactions. People have asked me before, like, what if I just use it for gambling? Well, to the extent that you didn't know, like if that was a form of entertainment for you, as long as you can kind of verify where the money was used and not just that I was sliding my kid $500 every couple of weeks. I was actually going to the casino and I lost it. that, you know, like if you can verify some of that, that's what they're looking for. Okay. Now, pre-planning is usually the best way for these long-term care and getting qualified. If you expect to have more than 5 years to prepare before needing the ALTCS benefits, that's where the pre-planning comes into. That is where we can do certain things like irrevocable trusts and protect more of the assets, because we can basically do that gift outside of that 5-year window where they're looking at it. Okay. If we're doing crisis planning means that we're going to need benefits in less than 5 years. And that's where we sometimes do some strategic gifting, where we know that we're going to protect half and we're going to have to pay the other half in penalties, or do some different things like that. But those are the things that we want you to consider with regards to it. Okay. Now, when you have to spend down the money, things that are allowable expenditures, right? Paying off your debts, including your mortgages and your credit cards. Exempt renovations to your house will include renovations to your house that make your house a place where you can continue to live longer rather than going into assisted living. So I know my mom recently, not that she's planning on trying to qualify for Medicaid, but she recently converted both of the showers in her house to be kind of zero entry, so that she could just walk in without having to step up over anything to get into it. That's a little bit safer as she continues to age. And, you know, we don't want her falling and breaking anything just getting in and out of the shower. So those, but, you know, if they look back, those would be the types of renovations that they would say are okay. ADA compliance type of stuff, you know, making sure that your kitchen is easier to access, your house, your front entranceway, your back entranceway are easier to access, those types of things. Hourly personal services contract. So if you wanted to hire somebody to come in a couple of hours a day or a couple of hours a week to come in and help you with getting showered, or, you know, making meals, or doing things that you can't do for yourself, those are allowable expenditures. Okay. One thing that I find to be really, really important is this purchase of an exempt irrevocable burial contract. Okay. Here in Arizona, you can put up to $9,000 in that irrevocable burial contract. It's really important that it's irrevocable, because that's what's going to allow it to qualify for Medicaid purposes and not be counted as a resource. If it was revocable, who's to say that you wouldn't just go and take that money back out of there? So it does have to be irrevocable. There is also something called a burial savings account. You're allowed to put up to $1,500 in that, but it's my understanding that between the two of them, you can only have a combined total of the $9,000. So for some people, they like the idea of the burial contract with a specific company or mortuary that's going to handle those afterlife things, but they like the idea of a savings account for burial to pay for things like flowers, or you know, things that maybe the facility isn't providing on their own. Okay. Purchasing an exempt vehicle is also a potential way to not only spend down some of the money, but also to set up the healthy spouse in a position to have a newer vehicle, a handicap compliant vehicle, to have not only spending down some of the resources, but to put them into a position of where they're going to have maybe the vehicle that they'll have for the rest of their life, right? So if I drive a 2017 vehicle and my husband drives a 2015 vehicle, and we can only have one vehicle and we need to spend down some money, we might turn both of those cars in, trade them both in for one car, and get ourselves a really nice brand new car that's going to cost a little bit more money, but that's not going to be counted as a resource for purposes of qualifying. And now I know that my spouse is going to have a car that's going to have less issues with repairs and maintenance and things like that for the future, because we, you know, a brand new car is definitely going to have less issues than a car that's, you know, 10 years old type of thing. Okay. Now the alternative is with that crisis planning, where we provide a gift with a known penalty, right? And again, that's a strategic move to try to save assets or preserve assets for the benefit of loved ones. at a time when we know that we don't have the 5 years to protect more assets. Okay. When it comes to long-term care planning, every situation is really unique. The amount of time that you have to plan, the sources of your income, the types of resources, all contribute to the different options that you have available for a long-term care plan. I tell people, don't expect your options to be the same as others. I used to do family law too, and I used to tell people too, don't expect your divorce to be the same as your neighbors, you know. So when you're looking at long-term care planning, insurance can be a great option if you start early enough and can afford it, right? 10 years ago or so, when I first started here, insurance was relatively affordable. It did a good job of covering the expenses. And as the companies discovered just how many policyholders were going to need coverage, we feel like the premiums have increased and the benefits have decreased a little bit, but it's still worth looking at. Okay, because sometimes something is better than nothing, and sometimes the insurance coverage can help extend the amount of time that you have before you have to qualify for a Medicaid program, right? When we're pre-planning and we have 5 years before we need to apply, as I mentioned, that irrevocable trust is often one of the better ways to protect the biggest resources. We can put your home in there, we can put in investments. Generally, we're talking about things that you don't anticipate needing access to on a regular basis, right? So for your home, you're just going to continue to live in your home, right? That's going to be titled to the name of the irrevocable trust. That really doesn't impact your day-to-day living, right? If we take some money from a brokerage account and also put that in there, the expectation is that that money that we're putting into that irrevocable trust is not something that we ever anticipate needing to touch. Okay, so we don't want to take stuff and put it into an irrevocable trust that we want to spend in the next 5 years. We want to maintain your quality of life. So we're not looking to take everything you own and shove it into an irrevocable trust. We're looking to say, what things can we put into and have protected that we actually don't expect that we're going to spend, and do it that way. Okay. And then crisis planning is when we don't have the 5 years before applying. You won't be able to protect as much, but there are some allowable expenditures. In addition, you may intentionally gift some money, triggering a penalty, but you know, it just allows a smaller portion of the assets to be protected. Okay. So some examples that I wanted to use, right? We've got our individual, our married individual, and our married couples. When we're talking about income, if you're under the income limit, there's nothing further to do. If you're over the income limit, create that Miller's Trust at the time of application and follow those rules really strictly, right? Similarly, for one member of a married couple, under the income limit, nothing to do. Over the income limit, we might be looking at a Miller's Trust. We might be looking at income shifting to get more money to the healthy spouse, okay? And when we're looking at married couples that both need it, under the income limit, nothing to do. Over the income limit, determine if Miller's Trusts are needed for one person or both, okay? And try to figure out how can we strategize to make that as simple as possible. When it comes to the house, for an individual, if it's in a trust, so if your house is in your revocable living trust, right, the one that you did just for probate avoidance, they are going to require that you take that out of the trust name and just have it in your name, okay? They're going to then put the lien on the property. And that's why part of the reason they want it out of the trust, because the lien on the property triggers at the time of your death. And so that makes it a little bit easier for them to identify when they can get a collection on that. If you've got 5 years to prepare, that's where you want to consider that irrevocable trust and possibly putting your house into that, okay? For a married individual where just one of you needs care, if it's in the trust, again, they're going to make you remove it out of the individual's name and put it into the individual's names. If you have that 5 years to prepare, look at that irrevocable trust. If the healthy spouse is still living there after they've been approved for benefits, consider how to protect the house from probate and future ALTCS applications. And that may vary by individual, but that's something to definitely, you know, take some action on while that healthy spouse is still healthy, okay? And if a married couple, both people need the care, again, you're going to have to take it out of the name of the trust, put it into the names of the individuals. If you have the 5 years, consider that irrevocable trust. If you're both moving to assisted living, it's going to be really difficult to keep that house, and the sale proceeds to sell the house, the sale proceeds are going to count as a resource. Renting the house isn't really a good option. That's going to be triggered to count towards income. So it's going to increase your income. And you are limited in how much equity you can have even in a rental property. And so those are things to kind of consider with that. So that can definitely be one of the tougher things. Now, one thing that I don't have in this, and it's kind of a side note, is that there is a federal law that says that if your child has lived in your home and has been providing caretaker duties for a couple of years, you need to move into assisted living and qualify for benefits. You may be able to transfer the house to them, and under this child caregiver exception, and the house can be transferred to them without any penalty. Okay, it's intended to allow that house to go to somebody who's prevented you and put in the time and effort to keep you from having to go into an assisted living facility sooner, right? I haven't seen this law in action that much. My preference would be much more to move it into the trust, into an irrevocable trust, and name that child as a beneficiary of the house in that situation. The other thing to consider with that child caregiver exception is that you're not going to get the stepped up basis on the house that the child might get if they received it as an inheritance after your death. So some things to consider, but sometimes when you're absolutely desperate, there are certain things that may be available. Allowable expenditures: if you're an individual, pay off your debt, get that irrevocable burial and cremation plan. And if you're young enough, you may be able to convert some of your resources to income through like a compliant annuity, a Medicaid compliant annuity. And so sometimes shifting those assets, right? If it's an asset, let's say it's a brokerage account, a cash account that I can access at any time, right? If I have to spend that money down before I can qualify, then I've spent everything. If I've converted it to an annuity and the annuity is paying out little amounts every month, and then I pass and some of the annuity can go to my family members, then I haven't necessarily spent it all. And so it's just one of those things of like, will this benefit me? Can it protect some of the assets? It's hard to say because nobody has the crystal ball to know how long you'll be getting benefits for and when you'll pass away. But it is just something else that you can kind of consider to help get you onto the ALTCS a little bit sooner, okay? If you're a married individual, pay off the debt, especially if the healthy spouse is losing some income. Get those monthly bills down a little bit, pay off the mortgage so that they don't have the mortgage payment anymore, pay off any credit cards, pay off, if you paid for solar or for windows or you have any of those personal loans, go ahead and pay those off. And then consider whether or not it's time to, purchase a new vehicle as well. Always the irrevocable burial and cremation plan if you don't have anything already prepaid. The last thing you want to do is have spent all of your monies, get on ALTCS, and then you pass away and suddenly your family is going to have to fund how they pay for those burial and cremation plans. And then when you've got a married couple with just one individual that needs care, sometimes we can convert some of the resources to income for the healthy spouse, right? So going back to that example where we go and we apply for the benefits and we've got $100,000 total, so we each have $50,000. We can potentially take that other $48,000 and convert it into an annuity for the healthy spouse. Income for them doesn't change anything for them. Spends down, the person's money that needs to qualify for the benefits. It's got to be Medicaid compliant, and so it may end up having some kind of reimbursement coming out of it, but it may be a good way to kind of help out the healthy spouse while not getting yourself into trouble and delaying the approval for ALTCS. All right. If you're a married couple, pay off your debt so that your family and your kids don't have to deal with it after you pass. And then again, that irrevocable burial and cremation plan to make sure that that's taken care of for everybody after you're gone. Trigger a penalty. Okay, so when we talk about crisis planning and we talk about some of those intentional gifts, making a gift to your children, knowing that approximately half of your assets will need to be used for self-paying care during the penalty period. For some people, their desire to provide something for their kids will want them to do this type of crisis planning. A lot of times when we do this, I say to the kids, don't spend the money, save it, because when you're in an assisted living facility and on ALTCS, you're not necessarily getting takeout food or all of the new pillows that you might want for your bed or new clothes that you want all the time. So I tell the kids, like, if you're going to get this gift, kind of set it aside and use it for quality of life things for your parents instead of just going out and blowing it, right? Because we're trying to be intentional about making your life as good as possible. If we've got a married individual, again, you could consider making the gift to the spouse or the children, knowing that you might be triggering a penalty. Penalties are the amount of the gift or uncompensated transfer divided by the divisor based off of local area costs. This is the actual amount that I have right now for Maricopa and Pima and Pinal counties. It's the $8,666 per month is the divisor, and for all other counties, it's $8,132 per month for the divisor. Okay. Married couples, again, consider making a gift to your children, knowing that half of your assets are going to have to be used to pay for self-care during the penalty period. Okay. Opportunities for things when you're applying for ALTCS, right? So if you're an individual, if your child's been living with you and providing care for years, thereby avoiding placing you in long-term care facilities, you may be able to transfer that property to that child without penalty. That is that child caregiver exemption that I just mentioned. Okay. Married individual, convert as much of the assets to income in the name of the healthy spouse as you can. In addition, you may be able to compensate the healthy spouse or a child for acting as a qualified caregiver. So, when we talked about what ALTCS provides, there was the assisted living, but there was also the homebound caregiver services, right? And so sometimes the spouse or a child of the family may go through the steps. They have to take some classes, they have to get licensed through ALTCS to be qualified in order to get paid, but they can get a little bit of money. It's not very much, but sometimes a little bit helps, right? If the married couple both need long-term care, they might be able to pay a child through the ALTCS system for that in-home care by getting them qualified as a caretaker and extending the amount of time that they can remain in their home. And then they might also consider, and then be able to possibly transfer that property to the kid. What I want people to consider, because oftentimes our family, both as the parent and as the child, I think this is a great thing to do. I get to be taken care of by my kid, and my kid gets to take care of me, and we get to spend extra time together, and this works out for both of us. But I want people to really take into consideration the detriment that can happen to the child by being the caregiver. They might be giving up important years of their career. And especially if you are spending down all of your assets, so they're not looking at an inheritance or something that is going to make up for the retirement that they aren't earning while they're taking care of you, or the other things that they're building in terms of personal wealth. I've seen a couple of examples where kids have kind of come out the other side and they're broke, they're unemployed, and they're just not in a great financial situation as a result. So definitely, weigh out all of those options and understand kind of what that means to do that. Yeah, so we're just about at the end. I'm happy to take some questions. There's a chat feature at the bottom right of your screen that looks like this little bubble. Please remember, this is a public webinar and it's something that will be added to our YouTube channel. So questions should contain generic information. Please, no personally identifiable information. But if you want to put a question in there, please do. We've got our previous webinars on our Keystone YouTube channel. If you just Google YouTube Keystone Law Firm, most of those come up, and you'll probably, for those of you who know Francisco, see his lovely face on most of those. Other resources that I want you guys to be aware of: the American Agency on Aging is a great resource for not only ALTCS, but long-term care health issues, other resources that they have. And then there's the azahccs.gov. That is the website for ALTCS and stuff like that. We've got some upcoming webinars coming up. Francisco and Carmi and I have committed to trying to do a webinar a month, one of us. So it's like 3 webinars each month, because we all kind of bring different things to the table. And so we are loading those up to our YouTube channel so that you've got the opportunity to come back and review those when you can. And, we just really appreciate you guys joining us, because we really believe that education is the key to having the right documents in place. And when it comes to your estate planning, they're an evolving set of documents. They should be reviewed annually, updated regularly, at least 5 years, especially for things like your financial power of attorney, if not sooner. And discuss it with your legal counsel and your family as appropriate, because we want to make sure that these documents are working the way that you intended, that your assets are going how you want them and expect them to. And laws change, people change, assets change. Those are all things that need to be reviewed periodically. So I just want to say thank you. I really appreciate having the opportunity to educate people on some of these things. And I know things like ALTCS is super scary, but hopefully this is kind of giving you a little bit more information in terms of how we handle ALTCS, how you get qualified, and what some of the strategies can be for you. Francisco, you got any thoughts on it?
I just want to encourage everybody who's here, if you know somebody
I don't hear you. I don't know if everybody else can hear you. I saw you unmute.
Yeah. Oh.
I can hear him.
Okay, thanks, Alexis. Then I'll assume everybody else can.
No, I'm still not hearing you. Alexis, do you hear him?
Yeah, I do. Yep.
I don't hear Alexis either. It must be me.
That's you.
Okay.
So
please go forth.
I was just gonna give you all one last chance. I guess not last chance, but on Friday, Intro to Wills and Trusts. I'll be hosting that one online at noon. If you know anybody who needs to do it or who needs to update it, I'll post the link here in the chat. We've sent an email out, but everybody is welcome to share that with family, friends. They don't have to be in Arizona. The topics that we'll be talking about are general enough. They're applicable everywhere in the country. So feel free to send it to anybody, and they are happy to join. Register for Intro to Wills and Trusts. So that's there in the chat. And I'll be going over the basics. What is probate? What's the difference between a will? What's the difference between a trust and power of attorneys, healthcare, all those things. So I'll be answering questions just like we do all the time on these. So feel free to share that, please. Would love to get that out to anybody that you guys care about. Otherwise, thank you, Michelle. Thank you, everybody, for coming. We will go ahead and sign off and wish you all a wonderful day. Didn't see any other questions come in on chat or anybody else raise hands. So thank you again, everybody. Have a wonderful afternoon. Bye.